This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Supreme Court's conservatives appear poised to give the president control over potentially dozens of independent federal agencies, overturning or narrowing a 90-year-old precedent called Humphrey's Executor that limits when presidents can fire agencies' board members. At oral arguments, they suggested they'll let President Trump fire Rebecca Kelly Slaughter from the Federal Trade Commission, despite a law that says commissioners can only be fired for specified reasons. The liberal justices expressed alarm at giving the president unchecked authority over about 24 agencies that regulate areas like nuclear energy, product safety, and labor relations. Here are Justices Sonia Sotomayor and Elena Kagan.
You're asking us to destroy the structure of government and to take away from Congress its ability to protect its idea that the government is better structured with some agencies that are independent.
So the result of what you want is that the president is going to have massive, unchecked, uncontrolled power, not only to do traditional execution, but to make law through legislative and adjudicative frameworks.
But the conservative justices like Brett Kavanaugh say the real concern is Congress's creation of agencies that exercise executive power but aren't accountable.
Independent agencies are not accountable to the people. They're not elected, as Congress and the president are, and are exercising massive power over individual liberty and billion-dollar industries, whether it's the FCC or the FTC or whatever it might be.
My guest is constitutional law expert William Treanor, a professor at Georgetown Law. Bill, tell us about the issue in Kelly Slaughter's case against President Trump.
The issue before the Supreme Court is that Congress puts limits on when the president can fire the heads of independent agencies. So an independent agency is like the Federal Trade Commission or the Federal Reserve. So really, since the start of the Constitution, Congress has imposed limits on when the president can fire these people. The question in the case is whether that's unconstitutional, whether the president can fire the head of an independent agency for any reason, even if Congress has said they can only fire them, if they're engaged in bad behavior. So this is a very big deal. So much of the government structure that protects people in different ways or regulates the economy is done through independent agencies. Congress has wanted to insulate them from total executive control, and the Supreme Court is deciding right now whether, in fact, the president has the kind of control that comes with being able to fire the leaders of the agencies.
In these oral arguments, you often hear the Supreme Court justices say, well, that's a job for Congress. That's not something that we should be interfering in. So why are they interfering here where Congress has set up these agencies and the rules?
That's a great question. There have been so many times in which the court is saying, this is a political matter. We shouldn't be deciding. But at the same time, the conservative justices of the court are very dedicated to what's called the unitary executive theory, which means that the president is in total charge of the executive branch. So what they're saying here is Congress doesn't get to be involved. The president is in total charge of, the executive branch, including what have historically been things like the independent agencies. That is kind of one of the core commitments that has really been at the basis of what Chief Justice Roberts has thought, really going back to when he was a young attorney. And that's the same thing for most of the members of the whole conservative wing.
What kind of concerns did the conservative justices express during the oral arguments about this 90-year-old precedent, Humphrey's Executor?
There are two things that we're seeing the conservative wing of the court struggle with. One is they want the Federal Reserve to continue to be independent. They don't want the president to be able to fire the commissioners of the Federal Reserve. And they don't want that because, that would be terrible for the economy. If the Federal Reserve is setting interest rates just in order to help the president rather than to help the economy, that would be a disaster. Be a disaster for the market. It would be a disaster for the economy as a whole. So the conservative wing of the court, I think, wants to overturn Humphrey's executor, but they're trying to come up with some rationale in which they can say the president can fire somebody on the FTC, but he can't fire somebody on the Federal Reserve. And they're going to be looking at the Federal Reserve later in the term. That's a big concern for them. So I think that animates all of the conservative justices of the court. I think also, what I'm hearing with the Chief Justice is what he's trying to do is to come up with some way in which there's some agencies where Congress can, in fact, limit the president's ability to fire people. And he's thinking about, are there ones that are essentially kind of judicial in their function? And, that may be an area in which Congress can establish requirements for when the president can terminate somebody. But that's not the Federal Trade Commission. Federal Trade Commission is not, making this judicial decision. It's very much deciding executive-type rules. So I think we're seeing two things on the conservative wing of the court. One is they're trying to come up with some way in which they can say the president can fire somebody at the FTC, but not at the Fed. And I think the chief is trying to come up with some way in which there's some type of agencies in which the president can be limited by Congress. But those would be ones that are really deciding kind of quasi-judicial matters, not the FTC. And he's going back. There's a case from the 1950s involving something. There was the War Commission. It was basically, making judicial-type decisions involving people. He's trying to preserve that line of precedent, even as he overturns Humphrey's executor.
The liberals painted a dire picture of what would happen if Trump wins here. Justice Sotomayor said to the Solicitor General, "You're asking us to destroy the structure of government." Do you think it's that serious?
I think that's absolutely right. We have had independent agencies which largely exist to protect people of limited power, and they've been in place really for 100 years. And the idea is that these should be basically bipartisan or apolitical. They should not just be tools of the president. So, what the court is considering right now is whether that whole kind of structure gets gutted. So the stakes on this are huge.
Well, President Trump wasn't specifically mentioned by name. Two of the liberal justices, Elena Kagan and Ketanji Brown Jackson, did make broad references to his firing of experts and dismantling of the Department of Education.
That the more realistic danger here is that we'll have an education department as authorized by Congress by law that won't have any employees in it.
Congress is saying that expertise matters with respect to aspects of the economy and transportation and the various independent agencies that we have. So having a president come in and fire all the scientists and the doctors and the economists and the PhDs and replacing them with loyalists and people who don't know anything is actually not in the best interest of the citizens of the United States. This is what I think Congress's policy decision is.
Do you think they were trying to remind their conservative colleagues about some of the actions he's taken?
So the approach to the unitary executive, what's motivating the court is pretty long-standing. So people like the chief have for a long time believed that the president should be able to fire the people who run independent agencies. So, for Chief Justice Roberts or for Justice Kavanaugh, the basic legal principle is one that they believed for a long time, long before Trump. At the same time, what we're seeing right now is that in the Trump administration, the independent agencies and all of the government watchdogs, there's an attempt to politicize them in a way that, we've never seen before. So the stakes are very different and they're much higher. If Humphrey's executor had been overturned, in President Bush 43's administration, the stakes would have been very different because President Bush was not focused on making independent agencies kind of the tool for his politics. But that's what we're seeing with President Trump, and that's why the stakes are so high. They've always been big, but in this administration, where there's such an attempt to kind of move away from scientific expertise and neutral decision-making to control every part of the executive branch. The stakes are huge, and that's really part of what the three liberal justices were questioning about. At the same time, I think, the other thing that they really are focusing in on are, first of all, it's very, very hard to come up with some line where you can say Congress can limit the president's ability to fire the heads of the FTC. They can't fire at will the heads of the Fed. It's very hard to come up, and I can't think of any kind of coherent way to distinguish those two cases. And that's one of the things that the liberals were pressing on. I think they're also pressing on the history. If you look at the Constitution, the text of the Constitution doesn't say that the president gets to fire people in the executive branch. It doesn't deal with removal at all. So, there's not a text that really helps the conservative wing of the court. And Congress really, starting in the Washington administration, limited the president's ability to fire people running agencies, or kind of what was analogous to modern agencies at the time. So I think what the liberals on the court are focusing on are, first of all, on the text, the original understanding, as well as the huge consequences of essentially giving the president the power to politicize all of the independent agencies.
I've been talking to constitutional law professor William Treanor of Georgetown Law. Bill, did you sense that any of the conservative justices might vote against Trump here?
I think that the chief may come up with, an attempt to limit the ruling, but, would align with Trump. The only one who I think is at all, from what I heard, who may vote against Trump is Justice Gorsuch. And I think what he's really struggling with is, he really thinks there are constitutional problems with the whole administrative state. So kind of thinking through how you feel about Humphrey's executor in that context, I think is complicated. So based on what I was hearing yesterday, I think he is the only one who I think there's some chance, would rule against the president. But I think at the end of the day, he probably would rule in the way the president wants.
I wonder what happens when there is a Democratic president. Do the conservatives then try to limit the ruling they're expected to make here?
One of the reasons why I think that the court should not overturn Humphrey's executor is, to the extent that you have any kind of political concerns, you're giving a Democratic president the power to do exactly what President Trump is doing, to politicize every independent agency in the way that president wants. And then how does a conservative court say, well, Humphrey executors is back? Once you establish a rule, it applies to everybody. That's something that they really have to think through because of the long-term consequences. Because I don't think they would feel comfortable, with limiting a Democratic president after they allow, President Trump to fire people whenever he wants.
So you think that they will completely overrule Humphrey's executor?
I think they will completely overrule Humphrey's executor. I think the one question for me is whether the chief comes up with some limiting principle in which, if there are, quasi-judicial independent agencies, then Congress can put limitations on the president's ability to fire. But I think, the basic point is I think they're going to overturn Humphrey's executor. And they've been, going in that way for some time.
If Slaughter is fired, that leaves the FTC without any Democratic commissioners. So then does that mean that you'll have these commissions where when there's a Republican in power, it will be all Republicans on the commission, and when there's a Democrat in power, there'll be all Democrats on the commission?
I think that's right. Because a Democratic president is going to say, I'm not going to have a bipartisan agency if, in Republican administrations, it's all Republican. You are setting up something which is new, which is that, independent agencies are not independent, and they just follow what the president wants. That's empowering Trump, but it's also going to empower Democratic presidents in the future. In these areas where you really want nonpartisan, where you want kind of balanced decision-making, that's going to go out the window.
The court in May called the Fed a uniquely structured, quasi-private entity, unlike other independent agencies. And here's what Justice Brett Kavanaugh said during the oral arguments.
The Federal Reserve, the other side, says that your position would undermine the independence of the Federal Reserve, and they have concerns about that, and I share those concerns. So how would you distinguish the Federal Reserve from agencies such as the Federal Trade Commission?
And just how would they do that?
Again, I think the thing that the conservative wing of the court is grappling with is what's the rationale for saying that Congress can't limit the president's ability to fire the heads of the FTC, but can limit his ability to hire the heads of the Fed. That's what they're struggling with, because it would be a disaster economically if the president could fire Jerome Powell. And so, they're struggling. They're trying to thread the needle so that the president can fire somebody at the FTC for any reason, but not do the same with the Fed. And, I think the historical examples to say that the first bank and the second bank of the United States, going back to the origins of the country, that those were areas in which there was a kind of autonomy that the president didn't control. But, there were also examples outside of the first bank and the second bank where the president's authority was limited. So I think what the court will try to do is to say the president can't fire Jerome Powell, can't fire Lisa Cook. But I don't think that is kind of a coherent approach, because I think it would be based on history, but the history doesn't support it.
A lot of times they seem to pick and choose the history that's useful. It's been great talking to you, Bill. Thank you. That's Professor William Treanor of Georgetown Law. The Supreme Court heard arguments on Monday on whether President Trump has the authority to make hiring and firing decisions for independent government agencies, like the FTC or the Federal Reserve. The case was brought to the court by former FTC Commissioner Rebecca Kelly Slaughter, who was fired by the Trump administration because they said her appointment was, quote, inconsistent with the administration's policies. She told ABC News that if the justices side with the Trump administration, independent government agencies from the National Weather Service to the Federal Reserve could be stacked with loyalists to the president.
Congress decided that when it set up these agencies like the FTC and like the Federal Reserve and about 24 others, that there should be some checks and balances in how the powers that those agencies have are used to avoid political interference. I've said from the beginning that this isn't about me or my job, and that was very much on display at the arguments yesterday. It is about not just the agency I serve, the FTC, but a whole host of federal agencies. And it was clear that it's really difficult to come up with any principled distinction between the FTC and, for example, the Fed.
Joining me now is constitutional law expert Gillian Metzger, a professor at Columbia Law School. Gillian, in your view, what's at stake in this case?
Well, there's a lot potentially at stake in this case. The specific issue in the Slaughter case itself has to do with the ability of the president to remove a member of the Federal Trade Commission without cause. But the logic of the Solicitor General's argument and the argument that many of the conservative justices seem to be embracing is considerably broader than that. It would not just extend to other independent agencies that have similar kinds of authorities as the FTC, adjudicatory and regulatory. It would extend to what are called non-Article 3 courts, entities that really function as courts but don't operate with the Article 3 protections. So the Court of Federal Claims, for example, was one that came up in the oral argument. And those are also entities that would, if you focus on the breadth of the Solicitor General's argument and the kind of claims of really unlimited removal power in the president over executive officers, it would encompass those. It would encompass the Fed. And of particular concern, it wouldn't just be limited to principal officers. It would be also encompassing inferior officers and in particular employees and the civil service. And one of the interesting aspects of the oral argument was there were definitely some justices who were concerned about the potential implications of their holding and of the government's argument and trying to find ways that they could decide more minimalistically and still hold for the government here without adopting all of these implications. And they were particularly concerned about the non-Article 3 courts and also the Fed. But it was only Justice Kagan who really pushed on how this would also apply to the civil service, and the conservative justices didn't refer to that. And that would be really quite extraordinary if it turns out that removal protections for the civil service, which are such a critical piece of our administrative state, are under this decision unconstitutional.
Gillian, I've asked this question more than once. Why do the conservatives embrace this unitary executive theory that gives so much power to the president, to another branch of government?
You know, it's interesting. This is a received conservative legal idea and principle that the president has unlimited control over the executive branch, that the Constitution divides the authority between executive, legislative, and judicial, and the vesting clause means the president is vested with all the executive power. And when I say conservative, I mean conservative in the political sense. This goes back to the Reagan administration, the birth of the conservative legal movement. And this was one of their kind of founding principles as a way of pushing back on administrative government and the administrative state. I think that still actually underlies a lot of this, that kind of resistance and suspicion of administrative power. What's interesting is other principles of that conservative legal movement are actually in tension with the unitary executive idea in this way. One of the things that's been established over time, particularly recently, there's been a huge burst of excellent scholarship, is that really at the founding, there was not this commitment to presidential unitary control over the executive branch. There are a number of instances of arrangements, commissions, Thinking Fund came up in the argument, the Revolutionary Debt Commission came up in the argument. These are entities that the president did not have full and unconstrained removal power over. There's just been a great deal of scholarship about the variety of kinds of appointment arrangements and institutions and how, granting a term of years actually meant to provide some removal protection. So there really isn't an originalist case for this. There were certainly arguments made at the founding that the president should have this power, but it's by no means obvious. And I think the weight of the evidence actually suggests that really that was not the view. And so, you have a lot of justices who are ordinarily proclaim their originalism, being willing to just blithely ignore the fact that this restriction that they're imposing on the political branches or are likely to impose has no historical founding and does not date back to the views of the founders. So that's odd. The other thing that's quite interesting is that, at this particular point in time, where we have a president who is asserting very aggrandized understandings of executive power and, refusing to adhere to statutes and limits enacted by Congress, statutes and limits that aren't at issue in this case, but broad refusal to adhere to a number of governing statutes, trying to dismantle agencies, spending impoundments and the like, that the conservative justices' concern was that Congress might make the Department of Education an independent agency. That really seems not to be the threat on the horizon. The threat on the horizon is a deeply aggrandized executive. And you would have thought that would have perhaps given more caution to them. I think the other thing that animates them, they have this image of the president being on top of the executive branch and a very simplistic model of political accountability where the president is nationally elected and therefore legitimizes everything that the executive branch does. And what they leave out of the equation is that there is extensive political accountability through Congress as well. And their model of very simplistic political accountability, this kind of chain of command way, just isn't how government operates. There's complicated, messy relationships, which in fact do yield a great deal of accountability, but it just isn't accountability in the model that they want.
They really gave short shrift to Congress and any congressional power. And I thought that it was interesting when Justice Sotomayor said to the Solicitor General, so you're arguing that the reasoning of the more current justices on this court has more purchase than the views of renowned jurists like Holmes and Brandeis and
Right.
Justice Story.
Right, exactly. And then you had Kavanaugh trying to revive the scale by saying, well, we also have Taft and we also have Scalia, which was ironic.
Scalia in dissent, usually.
Yes, exactly. That point was not noted. The other thing, and you may have noticed this as well, but when they're talking about reliance, so that, obviously stare decisis is a big factor in this argument. And when they're talking about reliance, several of the justices on the conservative side were suggesting that there was no reliance that mattered here because it was a structural issue, which is in essence to say the fact that for hundreds of years, our presidents, members of Congress, our political institutions have been operating and constructing a government on reliance on the idea that you could have these kinds of institutions. That doesn't count. And that was just a remarkable suggestion, I thought.
It seemed to me that the liberals had the best part of the legal argument. So I'm wondering how the conservatives are going to approach this decision.
I think they're going to go more minimalist. There were several suggestions of some things that the justices did not want to reach. The chief really seemed to want to carve out non-Article 3 adjudication, and the Fed, Kavanaugh similarly. Barrett also suggested, can we even not specify that this is based on the executive power clause, but this is just an authority to remove that the president has without specifying the full contours of it. The idea being, I think, that when it's based on the executive power clause is when it has its broadest implications versus if you conclude the president has power to remove based on the take care clause, that may impose some limits on the scope because a presidential removal power that's at odds with the statute being implemented would be harder to infer. And similarly, presidential removal power based on the appointments clause would really primarily extend to principal officers or those inferior officers that Congress gives the appointment of to the president. But for those instances where inferior officers are given to the courts or heads of department, the president wouldn't have the removal authority. And the appointments clause just doesn't speak to employees. And so it would leave that issue out.
Let's say that the conservatives, as expected, rule for the president here. What kind of changes would we see in the government? I mean, just changing the heads of agencies, will it make that much of a difference?
I think it does depend a little bit how they do it. So suppose what they do is they limit their decision to really independent regulatory agencies like the FTC, the NLRB, the Nuclear Regulatory Commission. These are agencies that have adjudicatory responsibilities and also rulemaking responsibilities as well as enforcement. And what they do is simply excise the removal protections for the members who head those agencies. That leaves those agencies standing, and it just would serve to allow the president to remove at will the members of the commissions. And I think would probably therefore also really eviscerate the bipartisan requirements that are in the statute right now for heading those agencies. There's no challenge to those bipartisan requirements here, except that if the president can remove at will, he can do what he's been doing, which is removing the Democratic members of these agencies. So that would be what we would see. There's some suggestion in the argument that the court should consider a different kind of excising and perhaps excise those powers that these agencies exercise that are executive and need to be within the president's control. That would be more of a fundamental change to the scope of these agencies, but would leave the possibility that the members of the commission that head them could still have some removal protection. My guess is that the court is going to do the former. It fits with what their precedent has been. And to be honest, it's the situation we're in already because the president has been removing the heads of a number of these independent agencies without cause. Lower courts have given injunctions requiring that they be able to stay in office, and the Supreme Court stayed them. So currently, these agencies are operating under the situation where the president can remove at will members of the commissions that head them. So we continue in that situation. I mean, the other thing that's just really striking is 1988 in Morrison. That is a Rehnquist opinion. It is incredibly lopsided in terms of upholding removal restrictions and rejecting all of the arguments that the conservatives were going for here. Rejecting the idea that the text is clear, rejecting the idea that there's a constitutional separations of powers violation, and adopting what's a very sensible line, which is basically removal restrictions are constitutional unless they impede the president's ability to perform the president's constitutional function. And that was 1988 and Rehnquist. And we're just in such a different landscape, and it's not that long.
Having this conservative supermajority has really changed the law in many respects. Thanks so much, Gillian. That's Professor Gillian Metzger of Columbia Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.